stated in the other case also apply to this case.
Were you served your
And that
notice
if
and
the
summons yet, Your Honor?
wishes to have counsel appointed, the court would consider or would appoint counsel to represent him in this matter, and he apparently wishes to proceed.
Were you served your notice
Having
and summons
notice
for federal
of
court?
the charges, sir, do you wish to still proceed without an attorney?
I just want to know, where do you get
Do
your
you
powers?
wish
Are
to
you an Article
proceed?
3 judge or an Article 6 judge? Where
Do
are your
you
vested
wish to
powers? Can you
proceed
answer
without
that?
an attorney?
You can't even answer
look
me
it
what your
up.
powers are.
You can look it up.
No, you guys disconnected my access to any kind of law library or anything. You are an Article 6 judge under the Michigan Constitution. You have no authority to deprive me of my
We'll
rights.
see how much authority I have. I will assume that you wish
This is
to
a matter
proceed
of
without
trust.
counsel. I will assume you wish to proceed without counsel and that you will wish to continue to proceed.
Practicing
without
law
counsel
from the
until you
bench.
inform the court otherwise. Call the case of the people versus Daniel McGough.
Good morning, Your Honor. Ashley Lottie for the people.
Sir, state your name.
I'm here on a special appearance, Your Honor. McGough is Easy Elastical Trust, registered in Jackson County, on case number 2522246.
Okay, is your name Daniel McGough?
Your Honor, that is the name you seek, and it is copyrighted and trademarked.
Okay, very well. Mr. McGough, are you represented by an attorney or do you wish to be represented by an attorney on these matters?
I am not.
Do you wish to be?
No. Not at this time.
Let me then do this. You have two cases before this court, one being the case ending, let me get the full case number 25 F40523. In that case, sir, the complaint does allege that on March 27, 2004, you committed the offense of operating while intoxicated. Do you understand what you're charged with?
I do not.
You do not understand
There is
that?
no eyewitnesses or corroborating witnesses at all.
I'm not asking whether or not the proofs are there. Do you understand what you are charged with?
I do not.
Do you understand the notion of drunk driving?
I do not understand how I could be
We've been
charged with
through this
something without a
before on
witness.
your other cases when you represent yourself, so we'll just do it.
Are you talking about the case that's in federal court right now,
You
Your
are
Honor?
before a complaint in that case for a charge of operating while intoxicated, third offense. Because it's a third offense, that is a felony. It is punishable by up to $500 to $5,000, up to 1 to 5 years incarceration. The court can order probation, 30 days to 1 year in jail, or at least 48 hours must be conserved consecutively. The court can also order community service, rehabilitative programs. The court can also order your vehicle immobilized, can order you to pay the cost of the prosecution as well as the cost of any emergency governmental services.
As I am hearing as a trust, Your Honor, I am hearing exclusive equity.
You count 2 on that complaint is the charge of operating while license suspended, denied, and or revoked. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs, and your vehicle could be subject to immobilization.
My license is
Count
canceled,
3.
not suspended or revoked. It
Count
is canceled
3
through the state
on
of
that
Michigan.
complaint
Canceled.
is the charge of escape from lawful custody. That is a misdemeanor punishable by up to 1 year, a $1,000 fine.
I was never arrested or read any Miranda rights accordingly.
Given that the defendant is talking in English, that he understands English, understands the nature of those charges and what he's charged against.
So malicious prosecution by
wishes
Washington
to
County
represent
prosecutor as
himself.
usual.
Sir, there is great peril in representing yourself. You will be held to the same standards as anybody apply or
This is a matter under the Eastern
not
District of
assist you
Michigan
in
Federal
any
Court.
way, or
Case
show
number
you any
2511226.
favoritism because you are not. I would further indicate, sir, that at any point during these proceedings, if you wish to be represented by counsel, you can make that request to the court and counsel will be appointed to represent you. Because of the defendant's conduct in the past in not acknowledging the court and what the court is saying, the court does make the presumption that he does speak English. He understands that. I would further state on the record that Mr. McGough has been through this process before. He does understand that if he does wish to be represented by counsel, the court would give him counsel or would have counsel appointed to represent him in this matter. In the case 25 F309 or 0979, in that case, sir, you are before a complaint that alleges that on or about July 3rd of 2025, count 1 is fleeing and eluding fourth degree.
Added on by the
Police
prosecutor's
officer.
office after the
Sir,
fact.
that is a felony, punishable by up
Malicious
to 2 years
prosecution.
incarceration and a $2,000 fine plus court costs, mandatory suspension by the Secretary of State.
My Secretary of
two
State, anything
is
is canceled. I have
operating
no contracts with the state of
vehicle.
Michigan.
That is a misdemeanor.
This is a
Charged
matter of trust, Your Honor. This is a matter of trust.
punished
I am protected
to
under a
90
trust.
days in jail, a $100 fine plus court costs. Count 3 on that complaint alleges operating a motor vehicle without security. That is a misdemeanor, not punishable by not more than 1 year incarceration and not less than $200 nor $500 fine plus court costs. Count 4 is operating while license suspended, denied, and or revoked. That is a misdemeanor.
All of my registrations are through the federal government. I have federal government
$500 fine
registration.
plus
I do
court
not have
costs.
contracts with the
Vehicle could
state.
be subject to mobilization. Count 5 on that complaint alleges refusal to obey refusal to
I have an international driver's
police
permit.
officer. That is a misdemeanor, punishable by up to 90 days, $100 fine plus court costs. I would indicate to the defendant the same admonishments regarding the perils in representing oneself that I stated in the other case also apply to this case.
Were you served your
And that
notice
if
and
the
summons yet, Your Honor?
wishes to have counsel appointed, the court would consider or would appoint counsel to represent him in this matter. And he apparently wishes to proceed.
Were you served your notice
Having
and summons
notice
for federal
of
court?
the charges, sir, do you wish to still proceed without an attorney?
I just want to know, where do you
Do
get your
you
powers?
wish
Are
to
you an Article
proceed?
3 judge or an Article 6 judge? Where
Do
are your
you
vested
wish to
powers? Can you
proceed
answer
without
that?
an attorney?
You can't even answer
look
me
it
what your
up.
powers are.
You can look it up.
No, you guys disconnected my access to any kind of law library or anything. You are an Article 6 judge under the Michigan Constitution. You have no authority to deprive me of my
We'll
rights.
see how much authority I have. I will assume that you wish
This is
to
a matter
proceed
of
without
trust.
counsel. I will assume you wish to proceed without counsel and that you will wish to continue to proceed.
Practicing law from the
until you
bench.
Inform the court otherwise. Ms. Lundy.
Thank you, Your Honor. Is the court completed the arraignment for the record at this time? on both
Well,
cases?
he had been arraigned. I was just admonishing him of the perils of representing himself and that it requires in part that I let him know what he is charged with. And I've read them kind of in fully, more so than I would have because he refuses to acknowledge those. So I am satisfied that he now knows all of the charges that are against him.
Thank you, Your Honor. The people would like to be heard on bond when appropriate.
What do we want to set this for? Do you wish to have a preliminary examination, sir?
This is a matter of a federal matter now, Your Honor, under case number 2511226, under the Eastern District of Michigan, under the Honorable Mark A. Goldsmith and Magistrate Judge David R. Grand. This
Do you
is,
wish to have-
this is,
do you
this,
wish
there
to
is
have a
no,
preliminary-
there is no proceeding here, Your Honor.
There is no proceeding. Oh, there's a proceeding.
Well, malicious prosecution is what the proceeding is.
Okay, very good. Do you wish to have a preliminary examination?
There's no proceeding, Your Honor. This is a matter that should be stayed and
What is
dismissed.
the people's position on whether or not we should set this for a preliminary examination or adjourn the probable cause?
Your Honor, I don't know if the defendant has received all discovery in this matter as he is representing himself, so I would request a probable cause date potentially.
Because you've got to send it.
Yeah, and who restricted my
So,
phone
probable cause
calls?
Conference, you know what?
Who,
You're gonna have to stop interrupting. I will give you an opportunity. You've been before me before. I will give you an opportunity to say whatever you want to say. But I'm not gonna have you interrupt me and I'm not gonna have you interrupt the people when they're talking. As long as you were saying.
Thank you, Your Honor. I have to there's video evidence in addition to the paper discovery. I've got to make arrangements with Lieutenant Arnett to work on that. So it may take just a bit longer. I would potentially look at the 7th, maybe, if the court would have entertained that. And then I will wait to be heard on bond when the time is appropriate.
I will adjourn the probable cause August 7th, 2025, 9 a.m. as to bond.
Your Honor, I've been reviewing X jail and I wanted to double check if the defendant had been arraigned. It's not clear to me from a couple of different things, but it does appear that he has been set with a $10,000 bond in 25F30979, as well as 25F40523, each $10,000.
Yes.
Your Honor, I do think it's important that the court have some additional information, and I would have to ask the court to revisit the issue of bond. First and foremost, I think it's important the court know that the facts alleged in the newest case, the 25F30979, It does include the fact that the Michigan State trooper who pulled the defendant over noted in his police report that the defendant had a license plate on his vehicle that indicated he was a diplomat and that he refused to identify himself. He refused for quite a bit of time. Additional units had to be brought to the scene from the sheriff's department in order to, for lack of a better term, deal with the situation. And ultimately, they were able to identify him as the defendant, Daniel McGough. The concern with that goes along with the other case, which is an OWI. It is charged as a third. I will note that it is a true fourth, to the best of my understanding. So there does appear to be an alcohol problem going on. And I also think it's important for this court to know, because I don't know that the court knows, the defendant has a third new case, telecommunications malicious use with a domestic relationship, that is currently pending as well. He's also been set $10,000, 10% in that matter. But I think
Where is that case out of?
that case is out of 14B, Your Honor, before Judge Washington.
A co-defendants with the federal case that you guys are both in, and this is a conflict of interest as both of you guys are defendants in my federal case.
Go ahead.
I also understand, Your Honor, that there is a municipal case out of Canton Township that was set for a jury trial in April of this year, where the defendant failed to appear. And there were jurors, there was a veneer that had been brought in. And I bring all of this up to say, Your Honor, that the people are concerned about the defendant's ability to remain law-abiding, because I'll also note for the record that at the time that the new resisting, obstructing, fleeing, eluding case and the telecommunications malicious use case came up, he was in bench warrant status before Judge Slay, is my understanding, for refusing to come after the case here had been bound over, refusing to appear in person. I say all of that to say this: I do think that $10,000 is too low. And I also am going to request a scram tether, because this is an OWI fourth alleged, as well as a GPS tether, given his history of failure to appear and failure to comply with court regulations. Thank you, Your Honor.
Is the bench warrant before Judge Slay still out?
She has bond denied in her case now.
His bond's been denied in that.
Yes, that's correct, Your Honor.
Got it. Anything you'd like to say?
Anything to do with any contracts with the state of Michigan are void ab initio for a matter of law, as I have an canceled driver's license and I have an international driver's permit. And that also relates to the Canton case that they're trying to stick me for a driving unlicensed suspended citation, in which that I have an international driver's permit, making it also void. All of my matters, including the vehicle that I'm registered under, are registered to the federal government, not the state, under the Federal Motor Carrier Safety Administration. All of these charges are frivolous and a part of a long pattern of malicious prosecution by Ms. Londy, the Washtenaw County Prosecutor's Office, and quite frankly, you, Your Honor.
Hearing argument regarding bond, the court does believe that it was an abuse of discretion, given the circumstances of this defendant, to set his bond at the $10,000 figure. After hearing argument, viewing the file, the court does believe that not only does the defendant pose a risk to the public,
No
I
victims.
certainly believe that the defendant is a risk of flight given those circumstances, and has indeed, or at least is charged in this case, refused to obey or fled and eluded.
That was added on afterwards. The police officer did not report that at all.
The court, given those circumstances, would in each case raise the defendant's bond, grant the people's motion. Defendant's bond in each matter is set in the amount of $50,000 cash here. Thank you.
The tethers I requested, if he is able to post, Your Honor.
I will.
Thank you.
I expressly do not consent to this court's jurisdiction and do not.
Well, then
Any
you are
rights.
not a named party, so if you're not consenting to this court's jurisdiction, sit down.
Good morning, Your Honor.
Good morning, sir.
Morning, Your Honor.
Good morning. State your appearance, please.
All right. Ian Redmond, P70599, on behalf of the plaintiff.
And your name, ma'am?
Doshia Banks occupant.
Pardon?
Doshia Banks occupant.
Doshia Banks occupant, Your Honor.
Okay. So you're not Miss Whitlow?
No.
So what is your position in this case as you see it?
If I may, Your Honor,
Okay, good. Go ahead.
Ms. Banks claims to be an occupant of the property. She filed a bankruptcy case listing the property as hers. The bankruptcy stay was lifted, which gave rise to our motion to reopen the case. The order lifting stay I would like to present to the court because it has some interesting language in it, Your Honor, which includes, it is further ordered that the bankruptcy court finding this filing of this petition was part of a scheme to delay, hinder, and defraud VMC REO LLC. Additionally, Your Honor, the bankruptcy court ordered, let me see, notwithstanding Rule 4001A3, a bankruptcy rule,
Right.
creditor VMC REO LLC may execute on its order immediately. The order shall be binding and effective despite any conversion of this bankruptcy case to a case under any other chapter of Title 11 of the United States Bankruptcy Code. Further, that the recording with the appropriate governmental entity of this order shall constitute a bar to refiling any case under any chapter of Title 11 of the United States Code as to the property located at 5779 Pinecrest Estates Drive, Ann Arbor, Michigan, the property in this case. A debtor in subsequent case under this title may move from relief from this order based upon a change of circumstances or for good cause shown after notice and hearing. Said bar shall be for 2 years from the entry of this order or until such time creditor relinquishes their rights to the property. This order came out June 24th of this year. I have a copy for you.
All right. Thank you.
I will note, Your Honor, that Ms. Banks has filed an appeal of that order in the federal Eastern District of Michigan. That appeal is pending, but the status quo as of right now is that there is no stay, and that order lifting stay holds until such time as the appellate court does something. Additionally, Your Honor.
Yes, go ahead.
Additionally, Your Honor, there is no stay from the appellate court. They have not issued a stay, and in fact, it would be appropriate that there would be a bond placed or an escrow order of some sort, because BMC has been the owner of this property for the past year and does not have access to it. Additionally, Your Honor,
There's more. Go ahead.
there's a lot going on.
Yeah.
Additionally, Your Honor, Ms. Whitlow, who, as far as I know, actually exists, but I don't have any evidence to that effect, has not appeared in any hearings in this court, did not appear for her deposition that she was noticed for in the federal case, and in a federal case, the federal court issued a show cause order to Ms. Whitlow that she had to present certain documents from this court, which she failed to do. Her deadline to do so was, I believe, July 3rd. Let me confirm that. Oh no, July 10th. And she did not supply any of those documents. I can present that show cause order if you would like.
I don't know that I need that because I'm not.
The reason that I mention all of this, Your Honor,
Go ahead.
is that this is $1 million house in Ann Arbor that Ms. Whitlow purchased with a mortgage and less than a year later defaulted. The foreclosure went through, the sale occurred, the redemption period expired, and we came forward to evict. Since then, there have been multiple bankruptcies. Ms. Whitlow filed 2 different bankruptcy cases. A young man who apparently lives in Arizona filed a bankruptcy case and listed this property as his residence. Ms. Banks has filed a bankruptcy case and listed the property as her residence. It should also be noted that Ms. Banks was a bankruptcy preparer and has been forbidden from the bankruptcy court from preparing bankruptcies for anyone other than herself. The order lifting the automatic stay talks about that scheme of fraud. I list all of these things to show that the scheme continues. And that's why we would like to reopen this case, because there is no stay in place. We would like to move forward with an immediate eviction, at most an 11-day vacate. And if for some reason that would not be amenable to the court, we would ask for an escrow order or a bond. On $1 million property, I think it would be reasonable that $10,000 a month rent would be reasonable.
Right. Thank you. Ma'am,
Yes, Your Honor?
what do you want to tell the court?
Well, just for 60 seconds, and then I wrote something up because I am nervous, quite nervous. But I, Doshia Banks, is respectfully appear specially and conditionally for the sole purpose of protecting federally vested occupancy rights and opposing unlawful state action. I expressly do not consent to this court's jurisdiction and do not.
Well, then
Any
you are
rights.
not a named party. So if you're not consenting to this court's jurisdiction, sit down.
Oh,
You can go because you're not a named party.
I have a lease.
You are not a named party on this. You may have a lease with someone else and
No,
then
I have
you
a
can
lease
go
with-
challenge it. With who?
With Whitlow. Ms.
Then
Whitlow, who
you
is
need to
supposed-
go against Miss Whitlow.
Pardon me?
Then you may need to go against Miss Whitlow. But if you're not consenting to the jurisdiction of this court, you might as well just sit down. You are not a named party. I do not have to hear from you.
Oh, I see. So I need to,
I don't know what you need to do, but
well, let me respond.
to what? You're not consenting to the jurisdiction of this court. Why am I hearing from you?
I'm recanting
You're recanting what?
what I just stated.
Which part?
The part that I stated that I'm not. Oh, I lost my spot, not consenting to this court's jurisdiction, so I'm going to recant that
So you are consenting to this court's jurisdiction?
at this moment.
Well, no, it doesn't work that way. You don't get to say, well, now it's okay, and then not later say no.
Okay,
You know what? Here's the problem. You've not filed anything with this court.
No.
So I don't know why, on those grounds, why I'm hearing from you.
okay. If I may, I do have time, I do believe, to go file an answer and counterclaim. I was just led under
An
false.
answer and
pretenses
counterclaim to what?
to their complaint for eviction.
You have a lease with allegedly, with Miss Whitlow,
Correct.
then that is who you need to pursue it against,
Okay. And
or whatever the heck you're doing.
well,
Because you don't have, there is no privity of contract to the extent there would be, or relationship as between the plaintiff in this case and you.
okay, I'm not really understanding, but
Well, let me put it a little bit more simply. If I grant the relief of the plaintiff in this case and grant an order of a judgment and an order of eviction in
Okay.
10 days,
okay,
any claim of your interest in that property, you have to go after the Whitlows, because that's the only person you have a contract with. Allegedly have a contract with.
okay. No, there is an actual contract.
I don't know that, ma'am.
We've actually been.
I don't know
communicating
that.
Okay, I know you don't know that. 'Cause it's not before you.
Correct.
I see, I see. So basically, the notice of removal that the Whitlows did,
They are not here. I don't know. I have documents that are not, that they filed with this court that are not signed. So I don't have to accept them. She has not appeared before this court, or they have not appeared before this court. And so as far as I'm concerned, any relief they're requesting, I can, and as of right, ought deny, and it should be denied also on the merits of whatever their motion is. But I can deny it because they're not here.
okay. Again, stating to me, I want to make sure I'm clear that my issue is with the Whitlows, not with VMC.
Ma'am, I am not giving you legal advice.
No, I
You're
don't-
telling me that you have a contract. I do not know that you have a contract, but if you wish to enforce that contract, that's who you're going to have the issue with. You're not going to have the issue with the plaintiff in this case because they have rights on the property.
Okay. All right, Your Honor, I will speak with the Whitlows that I have finally got an understanding of everything. And I will speak with plaintiff's attorney as well and continue to communicate with Remax, who has came by the house several times.
All right. Based upon the representation of counsel, I'm going to grant their motion to reopen this case. I'm going to issue a judgment in the plaintiff's favor for possession with a writ to issue 10 days of my signing. Should the matter be appealed, also contained in that judgment in order, the appeal bond, I would set at this time at a rental rate or a rate, and I have looked at the property which is involved in this matter, and it is a significant property. I don't think the $10,000 a month quite does it based upon my calculations. So any appeal bond would be set in the amount of $15,000 per month that would need to be paid to maintain the appeal.
Thank you, Your Honor.
All right.
I will prepare that and present it to you this morning.
Thank you.
May I say something? Our lease payments was not that high at all. I'm not sure what her mortgage payments were. That was not our amount we paid.
Then I'll tell you what. If the Whitlows wish to come and object to my order of $15,000 as an appropriate bond, they may do so. I do not believe that you have standing to object to the court's order. Thank you.
Thank you,
Okay.
Your Honor.
Thank you.
I know, you didn't write anything.
We'll await. I did.
Oh,
No.
no, I don't think so. I don't know if Mr. Fink is ready on.
Mr. Fink, are you ready? But hold on. I'm going to take about a 10-minute break because my head is hurting right this minute. Well, it's not hurting. I mean, I could go on, but I need about 10 minutes after that.
Thank you.